Next case on the court's calendar is Lamar Z. Brooks versus the state of Florida. Mr. Funk.
Please report. Morning. Mr. Brooks never knew that Mr. Davis was the father, although he believed that he was the father of this child. There's no evidence that Mr. Brooks knew who Rachel Carlson was. There's no evidence that Mr. Brooks knew who the baby was or who the father was or whether it was insurance policy.
But that's why you're saying that the state of mind of Davis prior to the time of the conspiracy being formed, assuming we disagree with you that the Gilliam conversation was improperly admitted, that those statements before you say would have been inadmissible. Now, why isn't, I know that Rachel Carlson's statement of her intent to go to Crestview that night, why isn't that admissible under that old exception that
the Bowen case?
The Bowen case, that a deceased person can make statements about the purpose and destination of a trip, and that's appropriate, was appropriately admissible.
There needs to be an issue of that at the trial, first of all, and it's not an issue in the Lamar Brooks trial that Ms. Carlson went to Crestview. And remember now, there needs to be a close reading of those witnesses, and there's 6 witnesses that were admitted under 8033 of the victim hearsay. Lauer, Bamer, Chalupka, Williams, Hatcher, and Lyons. They didn't just include statements of driving to Crestview. It's not as innocent as that, and the prosecutor knew what those statements included. They also provided motive for the homicide. Included in those statements admitted under 8033 included discussions of paternity papers being signed, child support, and what I'm saying is read motive when you hear that. I need gas money. I'm broke. I need child support. Walker Davis Jr. is the father of this child. These aren't statements, even if you, and I think the state hangs their hat on Bowen, even if that's true, and even if you believe that, and I don't believe it's a material issue in this case, whether she was in Crestview or not. It was never disputed that she was found dead in Crestview. We know that. And Walker Davis admitted being with her at the time of her death. It's not an issue in the Lamar Brooks trial. In the Lamar Brooks trial, whether it's an issue in Walker Davis trial, I'll say for Mr. Davis's attorney. But those statements included hearsay that provided the motive for the homicides, and that's why the prosecutor put them forward, not to show that Ms. Carlson went to Crestview with Walker Davis.
But the issue of paternity, wasn't there a birth certificate that shows Walter Davis as being the father of this child?
Why that goes to the motive is because if there's paternity, then there's a child support obligation. If there's a child support obligation, Walker Davis Jr. now has problems in his life. He needs to eliminate this problem, quote unquote, in his life. That's the motive for this homicide. That's why the state argued such. This is not a tangential point that the prosecutor made. This goes to the very heart and theory of the state's case. The very heart and theory of the state's case, putting forth Walker Davis's motive for the homicides in the trial of Lamar Brooks. Therein lies the prejudice. And that, coupled with the statement of the non-testifying co-defendant, Walker Davis' statement, made to Detective Worley on his confession. His confession that was 2.5 hours long, that implicated Lamar Brooks. Even if you believe there's a conspiracy, the conspiracy certainly ended at that point that he's trying to shift blame to Lamar Brooks and minimize that confession by Walker Davis, because to me, that is the most egregious admission of a statement by a non-testifying co-defendant, one that inculpates, in this case, Mr. Brooks. The court and the prosecution admit that the tenor of the statement of Davis, and I'm talking about the confession time on the 29th to Jerome Worley, was the purpose of which was to shift blame to Lamar Brooks. The state in its brief tries to suggest that that statement, the shifting blame confession, that is part of the conspiracy. That is part of the conspiracy. And I would suggest that argument should fall on deaf ears. How a blame-shifting confession, inculpating your supposed co-conspirator, can be part in furtherance of, and I would argue not during, the conspiracy is beyond me, quite frankly. how that happens. I think the state knows there's trouble with it. I think they understand the prejudice, given all of the circumstances and lack of evidence in the case against Lamar Brooks. The prejudice is obvious. It doesn't stop there, though. It doesn't stop there. The prosecutor, after admitting the 2.5-hour, well, he didn't admit all the 2.5-hour confession, admitting the statements of Walker Davis that inculpated Mr. Brooks, asks the question to Detective Worley, what did you do next after hearing this 2.5-hour confession? And his answer was, an arrest warrant was prepared to go get Mr. Brooks. The inference is obvious, and it was intentional. How do we know that? Well, it was obvious on its face. How do we know it's intentional? Look at his closing argument. The prosecution's closing argument said to this jury, I know you'll remember that confession by Mr. Davis, and oh, by the way, you didn't get to hear all of what he said in his confession. That means something. The inference is intentional. It's obvious that Mr.
Now, there was an objection made that was sustained.
Yes, ma'am.
But you're saying that because Davis's statement should not have come in at all, if they hadn't come in at all, there wouldn't have even been that inference that would have been able to be drawn.
The prosecutor did well in prosecuting Walker Davis because Walker Davis is the one who committed the homicides, and he re-prosecuted Walker Davis in the trial of Lamar Brooks. In that sense, he did a phenomenal job of prosecuting Mr. Brooks by re-prosecuting Walker Davis. And that's what he did. The problem is what we're here on is Lamar Brooks, not Walker Davis. And the evidence against Lamar Brooks was minuscule. The statements attributed to Walker Davis, that linkage was at the heart of the state's case, at the heart of the state's theory. Without Walker Davis, motivation isn't here. And I'd like to reserve what little time I have left.
You may do so.
Thank you.
Thank you.